welcome everyone to this webinar on California's new rules on AI and employment, what employers and vendors need to know. I appreciate that regulation and compliance might not be everyone's favorite, most exciting topic to discuss, but in the world of compliance, AI compliance now is an interesting time. Lots of regulations happening around the world, different states. This one coming in effect in just exactly 1 week today. So this time next week will be the first day of enforcement after an aggressive timeline of just 3 months, I think, since it was announced. It's obviously a AI regulation focused in California, so will have quite a big impact on the tech industry, predictably, and may well set the scene for other regulations to follow as well. Super excited to be unpacking this today and delighted to have a team of legal experts from Wilson Sonsini joining us to talk us through the rules and their impact and requirements. So I'll let the team introduce themselves in a minute, but we've got Maneesha, Nadeem, and Aaron to talk us through this. To kick off the intros, for those of you who don't know me, I'm Jeff, co-founder and CEO at Warden AI. Backgrounds in building AI solutions, particularly in regulation technology, which is how I wound up at looking at this AI compliance space that we work in. And briefly at Warden, we audit and certify AI systems are fair and compliant in HR technology specifically, and work with leading HR tech platforms as well as enterprises that are deploying AI solutions and mitigate the risk of doing so. So over to Maneesha and then Nadeem and Aaron to do quick intros to yourselves, and then we can get stuck in.
Great. So thanks, Jeff, for that introduction. It's great to be here to talk about AI rules and regulations affecting employment and recruitment. As Jeff noted, my name is Maneesha Mithal. I'm co-chair of the Privacy Cybersecurity Group in Washington, D.C. of Wilson Sonsini. I'm joined by Aaron Balabanyan and Nadeem Novakovic, who are in our California office, and they are employment experts. And so the way we're going to split this up is I'm going to provide a little bit of context setting. A lot of my practice is advising both AI vendors as well as employers in their use of AI systems. And so that's a perspective I provide. Aaron and Nadeem are more of our employment law experts. So I think you've got the full circle here of kind of guidance that you would need on some of these issues. Nadeem, if you could just go to the first intro slide. I know we are here to talk about the FEHA amendments, but I do think that it is important to set some context. There are a host of new laws around the world that apply to AI and recruitment. I've got some of them listed on this slide. Don't need to go through all of them in detail. The EU AI Act regulates high-risk systems, and AI systems used for recruitment or selection are generally classified as high risk. I do think there's some guidance that's going to be forthcoming from the European Union about what that means exactly in the context of employment, whether it reaches to systems that are just, for example, doing matching terms and where decision-making continues to be in human hands. There's a question as to whether the designation of such a system should be high risk. And I think there's guidance that's going to be coming out from the EU shortly that's going to illuminate that question. Moving on to the next slide. There is the Colorado AI Act. The governor has recently postponed the effective date of that law to July 2026. But similar to the EU AI Act, it regulates AI companies and vendors that make or are a substantial factor in making a consequential decision, which would include employment. Let's go to the next slide. There's a theme here that I just want to surface before we start talking about FEHA. Both Colorado and the New York law. So there's a New York local law that requires companies that are using AI in certain employment decisions to conduct a bias audit by an independent third party. But the law only kicks in if a company is using AI to, quote, substantially assist or replace discretionary decision-making. If you looked at the Colorado language, the AI has to be a, quote, substantial factor in making an AI decision. Going to the next slide. There are CCPA, California Privacy Act amendments that the California Privacy Agency just announced yesterday that would cover automated decision-making, including automated decision-making in consequential decisions such as employment, as long as that AI system, quote unquote, substantially replaces a business's, the human decision-making, essentially. So I just went through these very quickly just to lay some context. Like all these laws apply when AI is used as a, quote, substantial factor in making an employment decision. And so the question is, when is an AI a substantial factor? So let's think about that in the back of our minds as we go through the FEHA amendments, and we can come back to that question at the end of the discussion. And please do feel free to chime in with your questions. But with that just general overview, I'm going to turn it over to Aaron.
All right. The FEHA amendments are going into effect October 1, so coming up next week. And so that's just a high-level background. FEHA is the California law that, among other things, prohibits discrimination and harassment based on these various protected categories, such as race, religious creed, color, national origin, and all the different categories that you see there on your screen, right? And among the various ways that FEHA can be violated are one, through disparate treatment, which is essentially intentional discrimination against an individual based on their protected class, if that plays any role in the decision-making process. And then disparate impact. Disparate impact is when, even if there isn't the intentionality of discriminating, but it can occur when a neutral policy or practice disproportionately harms members of a protected class. So intent is a key difference there. These kind of concepts are going to be relevant in these amendments. These concepts were already there, but now these type of technologies are being brought into it. Say, hey, you can use these things, or these things can be used in order to engage in these wrongful acts. So the main regulation changes include, among other things, prohibited discrimination can occur even with these use of automated decision systems. We'll look at that definition of that in a second. And then the definition of the employer's agent, which, just as the employer may be held liable for FEHA violations, is being clarified and expanded in these regulation changes, as well as certain record-keeping requirements are being expanded as well. So we'll get into these in more detail. ADS is defined as a computational process that makes a decision or facilitates human decision-making regarding an employment benefit, i.e. hiring, employment, promotion, selection for training programs leading to employment or promotion, freedom from disbarment or discharge, compensation, provision of a discrimination-free workplace, etc. An automated decision system may be derived from and or use artificial intelligence, machine learning, algorithms, stats, and or data processing techniques. And ADS does not include, so there's some carve-outs, right? Word processing software, spreadsheet software, map navigation systems, web hosting, domain registration, networking, caching, website loading, data storage, firewalls, antivirus, anti-malware, spam and robocall filtering, spell checking calculators, database, or similar technologies, provided that you're not using these technologies to make a decision regarding an employment benefit. So it's not an absolute carve-out, but only to that extent. And some examples of ADS, Nadeem, if you go to the next screen, the definition provides some examples of what are these types of things that could be ADS, because it's a pretty broad definition, right? So using computer-based assessments or tests, questions, puzzles, games, or other challenges to assess applicants and or screen, evaluate, categorize, or recommend applicants for employment, or directing job ads or recruiting materials to targeting groups, screening resumes for particular terms or patterns, analyzing facial expression, word choice, and or voice in online interviews, or analyzing employer applicant data from third parties. For example, it talks about personal interviews or other screening of applicants shall be free of discrimination. That's not changing. That was always there. And it also always said, notwithstanding any internal safeguards taken to secure a discrimination-free atmosphere in interviews or other screening of applicants, the entire interview or other screening process is subject to review for adverse impact on individuals based on discrimination enumerated in the Act. For example, it adds an automated decision system that, for example, analyzes an applicant's tone of voice, if you go back to the prior slide, or facial expressions or other physical characteristics or behavior may discriminate against individuals based on race, right? If you're just using their tone of voice, expressions, etc. So it can potentially discriminate individuals based on race, national origin, gender, disability, or other protected category. So to avoid unlawful discrimination, an employer or covered entity may need to provide reasonable accommodation to an applicant. And they get into for example, based on religious creed or disability. So it gets into some detail on these sorts of ADS and how it can be used to potentially discriminate against applicants or employees. Nadeem, go to the next one, please.
Yep. And Nadeem, before we go on, it looks like we're getting a lot of questions in the chat about things like applicant tracking systems and what would constitute a substantial usage of an AI tool. So just to touch on that, I think, and I know you guys are going to talk about this a little bit more when we get to the Workday case, but I think those examples of things that are not covered, I think from the prior slide, Nadeem, I think the more we can shoehorn the argument that, hey, we're just like an Excel spreadsheet. We are sorting based on kind of keyword matches, the same way kind of an Excel spreadsheet could do. I think the more you can characterize a piece of software that way, the more you can make the argument that it's not covered by these regulations, and it's also not covered by the other regulations I've talked about. As long as you're leaving the decision-making in human hands and not replacing human decision-making, particularly under the other laws. Now, we can talk about the differences between FEHA and the other laws, but under the other laws, I think you could make an argument that you're not a substantial factor if you're always leaving the decision in the hands of the employers. Now, I think that's where the nuance lies, and something we advise clients on a case-by-case basis, and we make suggestions as to how to avoid falling into that bucket where you're substantially assisting human decision-making. So for example, if you're automatically rejecting candidates and not surfacing them to the employer, I think that would get you into more trouble. So I just wanted to mention those two things, given the questions we were getting in the chat.
Yeah, great, Maneesh. Thank you. And just to chime in there as well on Jason's question about if any applicant tracking system could be considered facilitating human decision making, I think we just touched on the decision making angles, but the core of an applicant tracking system, at least for decades, has been just storing and tracking like a spreadsheet the people at the stage they're at in the process. I think it's fair to say that type of component, that type of system, which is not doing automated decision making, would be safely in the excluded category. Correct if I'm wrong. And so we're really talking about not whole about tracking systems, but certain features that might fall into or close to the decision-making component. Hopefully that answers the question. Great. Back to you, Aaron.
Yeah. So bottom line, they're giving pretty broad guidelines here and saying it's unlawful for an employer to use an automated decision system or selection criteria, or including any kind of qualification standard, employment test, or proxy, something that may not in and of itself be a protected class, but is used as a proxy for a protected class to discriminate against an applicant or an employee or a class of applicants or employees. But it's subject to any available defense. And Nadeem, if you go to the defense slide, so you have your traditional kind of FEHA defenses. So for example, we mentioned disparate treatment and disparate impact earlier. So a defense for disparate treatment, right, intentional discrimination would be, hey, there was a legitimate non-discriminatory reason. You got to show there was no intent there. Disparate impact would be this was job related, consistent with business necessity, necessary to the safe and efficient operation of the business. And there was no less discriminatory alternative that would have worked just as well, because they could come back and say they could have done it in a less discriminatory way, but so you would have to show that, right? So you have these traditional kind of defenses, but more specifically now, they're saying relevant to any such claim or available defense is evidence, right, or the lack of evidence of anti-bias testing or similar proactive efforts to avoid unlawful discrimination, including the quality, efficacy, recency, and scope of such effort, the results of such testing or other effort, and the response to the results. So is this testing absolutely required? It doesn't say it's absolutely required, but it essentially is requiring it if you want it as a defense, right? So this type of anti-bias testing is going to be critical under these amendments.
And just a
quick question, don't mind me jumping in, and that implication of anti-bias testing, is that speaking specifically to vendor requirements or employers who are deploying ADSs, or both?
All of the above. And I think what Nadeem's going to get into now, where It's the coverage is expanding, right? Who's responsible for who, where you can't just say, I've handed this off to someone else, I'll close my eyes and let them run with it. It's taking that option off the table.
Thanks. Sorry, Nadine, cut you off.
That's all right. I just wanted to highlight, in addition to what Aaron mentioned, notice that the regulations don't provide specifics as to when or how to run the bias audit test, but it just generally say that the efficacy, recency, and scope of such efforts are going to be taken into consideration. For example, you might do something every year or every couple of years, depending on the circumstances of your case. All right, so Aaron just went over the first FEHA regulation change, essentially the fact that you cannot offload responsibility under FEHA to an ADS. You can't use an ADS as a defense. If you discriminate even through an ADS, you could be held liable. The second FEHA regulation changes target the scope of who can be held liable to begin with. So traditionally, as you see on your screen, FEHA covers employers, employment agencies, the agent of the employer, labor organizations, and apprenticeship programs. And so the FEHA regulation changes in question that are coming in October 1st, 2025, expand the definition of who can be considered as an employment agency. And it also provides a definition for who can be an agent of the employer. I just want to make clear that both of these were already covered by FEHA as potential targets for FEHA claims. Employment agencies, those are folks who essentially are out there to procure job applicants. Employees are opportunities to work. Traditionally, these would be staffing agencies or even recruiters who are going out there to find a candidate on behalf of the employer. Folks who are just passively collecting resumes or applications and screening them on behalf of the employer would not traditionally have been seen as employment agencies because they're not out there procuring the job applicants or employees or opportunities to work. They're just providing maybe a software landing page for an employer where folks can apply and submit their application, and they help the employer screen those applications, but they could be considered an agent of the employer. And an agent of the employer has traditionally been any person acting as an agent of the employer if that agent has at least 5 employees and carries out a FEHA regulated activity on behalf of an employer. So as I mentioned earlier, the FEHA regulation changes slightly expanded the definition of employment agency. So before it just meant categorically any person who for compensation procured job applicants, employees, or opportunities to work. The new FEHA regulations now say that it includes, and by saying it includes, it implies that it's not limited to these folks. So potentially, perhaps the FEHA regulations are contemplating additional folks to be covered by this definition, but they don't really explain who those additional folks might be at this time. And they, of course, added the clarification that it includes employment agencies who are the folks who are for compensation, procuring job applicants, employees, and opportunities to work, including if they're doing this through an ADS. So again, if you're doing employment agency work, you can't offload responsibility under FEHA by just adopting an ADS and blaming the ADS system. This is the big piece on the scope of who can be held liable. It's the added definition of agent. Before there wasn't a definition of agent, but again, just under case law, in the general FEHA statutory language, there was the idea that an agent of the employer could be held liable. Now we have an actual definition under the FEHA regulations. An agent includes any person acting on behalf of an employer, directly or indirectly, to exercise a function traditionally exercised by the employer or any other FEHA regulated activity. And that could be things like applicant recruitment, applicant screening, hiring, promotion, or decisions about pay, benefits, or leave. And again, this includes if that agent is conducting these FEHA regulated activities through an ADS. This is consistent with the recent Supreme Court decision, California Supreme Court decision in 2023, where an agent of the employer was held liable under FEHA, or the claim against the agent was allowed to proceed. And the California Supreme Court essentially reasoned that the agent is essentially what this FEHA regulation definition of agent is and applied FEHA to that particular employment screening company. Now, a lot of folks might be thinking, okay, these are FEHA changes. What about on the national level or on the federal level? You're right if you've noticed that on the federal level, there might not have been any statutory or regulatory changes. So Congress didn't pass a new law. There's no new regulations that have been passed that kind of deal with this issue. But through case law, what we're seeing is that some courts are starting to adopt this idea of applying anti-discrimination laws, the federal anti-discrimination laws against agents of the employer, including those who are using ADS. So you might have heard about the Mobley versus Workday case here in the Northern District of California. It interpreted federal discrimination laws similar to how FEHA regulations clarified FEHA now. Essentially, Workday used an AI tool to help employers screen and evaluate candidates. An applicant sued Workday, alleging that race, age, and disability discrimination occurred through their AI tool. And so the Workday itself was not the employer. They were just helping a bunch of customers who are employers try to hire candidates, and it just provided its AI tool. And the court found that Workday could be held liable for discriminatory acts as an agent of the employer under federal laws because it conducted a traditional employer function. And as Maneesha had mentioned earlier, the test, there's no clear line in the sand, but essentially if you are performing traditional employer functions, you're evaluating what's important to the job, you're evaluating or assessing the candidate itself, and then you're making some sort of an assessment to figure out who is strong, good, fair, or who should be recommended or not recommended. That is akin to a traditional employment function because that's something a traditional hiring manager would be doing. But if on the other end of the scale, you are merely applying criteria in a rote manner, similar to an Excel spreadsheet, where you're just applying a particular criteria and organizing folks, you're not actually doing any type of assessment or analysis or making any type of judgment, then you would not be performing a traditional employer function. The tool in question that Workday was using, the court thought that given its nature, it seemed more like it was performing a traditional employer function because, again, it was assessing and evaluating candidates and recommending them based on whether they were strong, good, or fair. And it wasn't just applying criteria in a rote manner. So just quickly, key takeaways is essentially the changes on the federal discrimination laws are developing through case law, even if maybe statutory or regulatory changes are not happening yet. Until more formal statutory or regulatory changes or clarifications are implemented, it is safest practice to assume that throughout the United States, federal discrimination laws could be interpreted to cover AI use the same way that FEHA is covering AI use under anti-discrimination laws, but this might change from circuit to circuit because different judicial circuits might interpret federal laws differently. The last change here for the FEHA regulations deals with the record-keeping requirements. So it clarified that employers should keep records for 4 years from the date of making the record or the date the personnel action occurred, whichever occurs later. And more importantly, it identified that the data that should be maintained, of course, includes what was needed to be maintained before, like application, personnel records, membership records, and so on. But it also includes ADS data. And ADS data is defined as any data used in or resulting from the application of ADS, such as data provided by or about individual applicants or employees, or data reflecting employment decisions or outcomes, and then any data used to develop or customize an ADS for use by a particular employer or other covered entity. In addition to the FEHA specific regulation changes, just to flag for folks who are here, there are additional California specific AI legislation that might go into effect, but has not gone into effect right now and hasn't really been signed into law. But there's, for example, the first one, SB 7, the No Robo Bosses bill. So that was recently, it's not enacted, but if it's implemented, it would go into effect January 1st, 2026. It would preclude employers from relying solely on ADS for critical employment decisions. including employee discipline or termination, essentially would expect there to be a human element to making at least the discipline and termination decisions. And employers would also need to provide employees with certain notices in connection with using ADS for hiring or employment-related decision-making and limit data collection through the ADS system. The other bills are the AB 1221 and AB 1331. The 1221 bill seeks to impose transparency requirements for use of workplace surveillance technology and limit employers in collecting and using certain types of employee data. So including if you're using it through the ADS system to collect the data, you should have to keep in mind that this might impact your ability to collect that data. And then 1331 is just setting boundaries and geographic limits to where employers can surveil employees, including through ADS. So things like in break rooms or cafeterias might be off limits.
Okay, I think I'll take this slide. And I think before we get to these recommendations, but a couple of takeaways from the discussion. Number one is I talked about kind of substantial factor in decision making. So I think that, again, just to reiterate, that's something that's in the other laws, the kind of EU AI Act, Colorado, New York. But I didn't see, and Nadeem and Aaron can correct me if I'm wrong, but I didn't see that in the FEHA. So while somebody might say, I don't have to do a bias audit under New York because the hiring decisions are human-led and the ADS is not a substantial factor in the employment. I don't think companies have that argument in California. So I think that's one, key takeaway from the California regulations. The other thing I just wanted to mention, and somebody put this in the chat about kind of auto rejections. Again, Nadeem and Aaron should keep me honest here, but I think one of the factors in the Workday case was that applicants got auto rejected like 5 minutes after submitting a job in the middle of the night. And so I think to the extent that companies, the AI vendors have dashboards and toggles for employers to be making decisions, maybe they're bulk decisions about rejections, I think that probably is going to be safer than some of the kind of auto rejection capabilities that people are offering. Okay, so what are our recommendations? Consult legal counsel for advice, review all the changes. Okay, I want to talk about this fourth bullet a little bit. Audits are critical. So again, must you conduct audits? It may not be a legal requirement that you're violating if you don't conduct them, but I think it's probably wise to conduct them. But I want to say a few words about privilege. So let's say you're an employer and you hire a vendor to conduct a bias audit, and the bias audit comes back and it says your system is completely biased and you've done a terrible job in remediating bias. That's something that you probably wouldn't want to get in the hands of a plaintiff's lawyer. And so one of the things that we often work with clients on is figuring out how to conduct bias audits under privilege. So having attorney-client privilege, a couple of tips there. Number one, if you're going to hire an AI vendor, have that be done by your legal team. In-house legal team is good. Outside counsel is better because courts have said that in-house legal teams also serve a business function. And so hiring outside counsel and having the bias auditor proceed under the direction of counsel is what may give you the most privilege protection. Making sure that you're not sharing bias audits with your whole company, only sharing them within your company on a need-to-know basis. And so I think those are the types of things that can help make sure that those bias audits are being adhered to. Those kind of requirements are being adhered to. I think maybe the last bullet here on this slide is also worth discussing, considering using contractual protections, indemnification, arbitration provisions. Again, this is going to largely depend on the bargaining power between kind of the AI vendor and the employer. But that's something that kind of I know companies are considering as to like how to contract around some of these issues. Nadeem, Aaron, anything else you want to highlight from this slide? Okay, I think with that, we're ready for questions. And I think we tried to address some of the questions as we went along.
I think there's still one that Jenny asked in the chat. I think it's a good question where she's saying you mentioned disparate treatment requires intentionality. Does this mean that disparate treatment is only fulfilled if employer deploys an AI screening tool that is knowingly biased but not fulfilled if it is biased unknowingly to them? And that's where the concept of disparate impact comes in. And the emphasis on this, if you look at the updates and the regulations, there is a lot of emphasis on disparate impact, right? Where there is not intentionality necessary, right? It's a neutral thing, and you may not be cognizant saying, okay, this is going to discriminate against this group and the data that's going in, but in effect, it is, right? And that can violate the regulations. So it does not require intentionality. It can be neutral, yet have a discriminatory impact.
That makes sense. I think maybe there's a sort of another angle to that question, which is fair enough that obviously disparate impact can happen unintentionally, and that's still breaking the law and important. I think that maybe even getting at is, would it be classified as the actual disparate treatment if the system, the screening tool, is knowingly biased? If they know there's some bias in it and you carry on using it, is that then disparate treatment? Because is that like almost intentional because you know there's a bias in the system and you still use it? Or would that still be a disparate impact?
It could either, they can try to argue with both, like they could, but I think if there is potential, like, hey, I know this is biased and I'm using it, then yeah, I think it can go into disparate treatment.
I think the key term would be if it's a substantial motivating factor for making the decision, if the protected characteristic is. And so I think if you have a tool that uses a protected characteristic or proxies for a protected characteristic to screen out folks of a particular protected characteristic, then I think it would be a pretty strong argument for somebody to say that was a substantial motivating factor in making your decision, even if you used an ADS tool to do it.
That makes sense. Thanks for clarifying. Brilliant. Is that all the slides from you guys? Fantastic. Thank you so much. Really insightful, detailed information. Thanks everyone for the questions. We've got a lot of them. We've tried to cover a good number already. Keep them coming. I've got a few questions I'll ask while we allow people to ask more as well. One thing that is interesting with this law and the other case law that you're mentioning, like Workday, is obviously putting more emphasis on how essentially pre-existing discrimination protections now are also applying to AI and automated tools. Does that mean that an employer who is using an AI kind of automated tool, how far in the grey it may or may not be in terms of full accounting as an ADS, does that mean they carry more risk than before of just using like human-based processes? Or is it just different? Because obviously if discrimination happened in a human-based process without AI, that's still breaking FEHA and they still have risk there. Have you any thoughts on how this changes and increases or even reduces the overall kind of discrimination risk of an employer who might use a tool like this? And then Maneesha, if you...
Yeah, so look, I think the discrimination law is what the law is, right? So we've talked about disparate treatment, disparate impact. I think this adds, I think, a couple of things from my perspective, and I'd be curious as to the others. One is that it adds a layer of responsibility on the AI vendors that maybe they could have been held liable as agents before, but I think this makes it all the more clear. And I think that there's a lot of procedure. So again, my expertise is more in some of the other laws, but I think the other laws include a lot more procedural requirements. So not only a bias audit, but in kind of Colorado and EU, there's risk assessments and kind of transparency requirements and things like that. So I think AI, because of the scrutiny of AI and some of the state law developments on AI, I think it just puts more of a target on your back.
I also think that there's a tendency or the temptation with AI to say, okay, it's going to do its thing, right? As opposed to with a human perspective, okay, we're monitoring, etc. But AI is there, it'll function, and kind of the temptation to take a more hands-off approach, right? And I think this is a reminder that no, you got to be on top of it, and you are responsible for what your AI and these other technologies do and what your vendors do as well. So as we mentioned earlier, that it can't just be I'll outsource and close my eyes, right? But you got to be involved in the process because that's not an excuse on either party's side. So I think it's also combating that temptation. So to your point, sometimes AI, the risk is the risk, but AI can dull our senses in a sense. And this is a kind of reminding us to be on top of it.
Yeah, I think that's a great point. And I think this argument that, oh, it's a black box, right? I think that's exactly what the regulators are trying to address. And so I think, yeah, Aaron's point is a great one.
And then that's where the risk is now somewhat different and maybe arguably slightly higher because before, without the ADS tool, you had a little bit more control, right? So if you have Johnny Smith working for you, a hiring manager reviewing resumes, he can more easily control his own actions and think about what he's thinking and what's important to the job and what's important on the resume. Whereas now when you have an AI tool doing it and it's trying to interpret whether somebody's quote unquote resilient or hardworking or something like that, you don't necessarily the lack of control there and what type of process or algorithm it might be using. It's a little bit more difficult to control. And so because of that difficulty to control, and now this need to do the testing and making sure that it's not relying on any protected characteristics, I think that's where the added risk comes in.
Yeah, no, that makes sense. Thanks for the comprehensive answer. To switch topics slightly, to talk a bit about, I guess, the impact perhaps of this particular regulation, given it's in California. Do you see these rules with FEHA and the principles here? How broad do you expect that reach and impact to be beyond just employers and vendors in California? And do you think there's a chance that this sets a sort of de facto national standard, a bit like CCPA and privacy law has had quite a broad reach beyond just California itself? Any thoughts on that?
Yeah, I do think that. And I think that the Mobley versus Workday example is the one that is striking fear in the hearts of people in this space across the country. And so I do think, and I think if you look at all these things, Mobley versus Workday, the FEHA amendments, they're all getting at the same thing and they're all pointing to the same solution, so to speak, which is to, if you want to be out of these decisions, regulations, et cetera, characterize your product more like an Excel spreadsheet. Now, your business people are not going to want to characterize your product as an Excel spreadsheet. They're going to want to say, oh, there's a lot of bells and whistles and interesting things that we can do. And so I think that's the kind of conundrum.
But to add what Maneesha also said, I think even without the ADS tools that are coming up right now, you could still have been found to be an agent of the employer if you just conducted those screening activities, right? So if, let's say, the employer offloaded it over to a screening company who then reviews, even without the use of AI, who just reviews resumes, evaluates them, and then recommends people as strong, weak, whatnot, you could still potentially be an agent under FEHA and be targeted with the FEHA claim. It's just that now with AI use, it's much easier to assess candidates and it's becoming a little bit more prevalent to target agents.
Yeah, that makes sense. It's really that redefinition of what counts as an agent, I think, is quite an important part of this, and also the case law that you're mentioning. In terms of the compliance with this particular law, obviously there's not been a huge amount of notice period. I think many people, including someone on this call, probably only very recently even heard about it, never mind whether they may or not be fully compliant in 1 week's time, to be candid. How do you expect that to play out? Do you think, is everyone going to be ready the 1st of October? Is it more realistic that alignment will take months, years to catch up? What any thoughts on how people will play into the compliance with the law?
I do think that even independent of the law, these are the types of things in commercial arrangements that companies are asking about. So if I'm an AI vendor and I'm looking to sell my product, I think chances are it's the first question businesses are going to ask, like, how do we know that your product is not biased? And so I think there's a business imperative in addition to this kind of legal liability. And that's not to say that the law is not meaningful and it's not going to change things, but I just think that it just reinforces some of those commercial considerations that are going to be at play.
It's just a part of a wider kind of landscape of various reasons to get this right.
Yeah.
And of course, California isn't very forgiving, right? To say, oh, we didn't give you too much notice. Okay. So I think employers have to be on top of it, right? In a sense, it's not changing that you shouldn't have been discriminating, right? And you should have been on top of these things anyway. It's just giving that greater sense of urgency and also bring the anti-bias audits into more prominent, into importance, right? To say, okay, while it's not saying, hey, October 1, I have to have the audit done necessarily, but it's becoming critical to be on top of it for defense purposes and to examine your vendors and to be involved in that process. So you should assume that, yeah, by October 1, you should be complying, right? So late notice is unfortunately not an excuse under the law.
Yeah, it makes total sense. Yeah, as it happens, we're very busy at the moment, more than the run up to that deadline. And I have also trained of thought on my follow-up question there, but I see someone's just put a question in the chat, so that's my get out jail card there. So Susheta is asking if all AI-related laws we discussed require self-compliance by the organization. As our first question, I think there's several questions here. Then does anyone want to take?
Yeah, maybe I can take some of these. So I'm glad this question was asked, because I think there's another kind of distinction between some of the laws. So the New York local law requires an independent third-party bias audit. I don't see anything in the FEHA amendments that require that the bias audit be by a third party. Now, that said, is it going to look better to have an independent third party do a bias audit? Probably. But again, I think that if the company would use an internal bias audit as a defense, I think that may also work, but I'm curious as to others' views. And I think some of these other questions may actually be directed more to you, Jeff. Define structures for AI vendors.
Yeah, I think at least with this regulation, there's not, if that's what the question's at, there's not a third-party certification that's required. As you mentioned, there's this bias audit implication, which potentially could be internal, but obviously third-party makes a lot of sense too. There is no well-known defined structure for vendors to follow for this, as far as I'm aware. Actually, that was going to be a question I had to follow up there, Aaron, which relates to this, which is when it comes to the law going into effect on the 1st of October, yes, it introduces new rules that could be needed in defense and all sort of thing. But is there actually like a regulator who's going to be knocking people's doors and checking, are you compliant with this? Or to what extent is that part of this law? Or is it a case of just, if someone were to make a lawsuit, here's the rules we would look at, and how would that play out?
It could be both, right? I think it's more likely to be the latter, right? Direct lawsuits, or either by individuals or classes, but it could certainly also be audits. Nadeem,
Got it. So the regulator can audit and may do that on certain people.
Yeah. Got it. Nadeem, do you have any thoughts on that?
Generally agree. I think the main intent of the regulations is just to say that the traditional way that folks could sue you for discrimination, they could also do it if you're doing it through an ADS. So the vast majority of cases are going to be like Mobley versus Workday, where an applicant is just disgruntled over the use of the ADS and they're suing for discrimination. And then within that dispute, you're going to be evaluating whether or not you've discriminated. And of course, it's not just the bias audits that you may or may have not done on the ADS, but it's your just general practice, right? Do you have equal employment opportunity policies, right? Do you do HR training? And all of that is going to be relevant. But of course, if you are using ADS, the bias audits are going to be important.
Yeah, and I think, not to be cynical, but I think that, Workday example, it's okay, so maybe particular employers may not have the deep pockets, so I think this is a natural next wave of kind of companies to be looking at. So I think that's another thing that we could expect to see.
Yeah, brilliant. We have a couple more questions, one from earlier as well, that I think a lot of them are gravitating towards this grey area of what actually counts as an ADS and what isn't, which we've already spent some time on. There was one further up from Bob Foley asking about recruitment marketing. So that's things like job ads and that's optimizing job ads, etc. Is that an area that might be in line as an ADS, or do you think that's out of scope, or in the grey area?
I saw that in one of the slides that was an example used in FEHA. Yes, this one, directing job advertisements or recruiting materials to targeted groups. I guess the question is AI being used to do that? And if so, I would read that as falling under ADS, but others can chime in.
I think the main concern is, let's say you have ADS target potential candidates. Again, if that ADS has some sort of algorithm that it's using that ultimately disproportionately affects certain folks, then I think the likely situation is that is going to be deemed an ADS, and you're going to have to answer for that type of disparate impact, right? Whether it's job related or business necessity, and whether you've been doing audits or not.
Makes total sense. And then Bob's second part of his question was, in this context, what would be considered a targeted group in a job advertisement?
That's a good question. The regulations didn't really define the targeted group, but if I'm just reading it based on plain meaning of the term within the context of FEHA regulation, I think if you're focused on a particular type of candidate, let's say software engineer with 8 years of experience, and that's the type of candidate that you're trying to target with your job advertisement, and then the job advertisement end up being predominantly issued out by that ADS to younger white men instead of women or older, potentially older applicants, then that's going to be a question of whether or not that ADS has disproportionately discriminated against candidates based on their sex or their race.
Yeah, even though they're not necessarily inbound applicants, but going out to target people. I think that's a very interesting example to be given in the law directly, because as we're seeing in a bit of chat about Bob Pulver is also commenting on this, in HR tech space, I would say that there's a lot of programmatic advertising that sometimes brand label itself as AI, whether it's truly AI or not, is up for debate. And at least to date, I think mostly they've felt like they've been clear of AI bias concerns. I don't think there's too many audits going on in that category of the market. But taking this at face value, with the FEHA regulations, it does sound like that is a use case that should be considered an ADS.
And just one clarification on this slide, this is saying, and these aren't necessarily like, these are ADS, but these are the types of things that ADS can be used to perform tasks such as these.
Of course, yeah, just because that use case happens, e.g. job advertisements, it doesn't mean it is necessarily an ADS,
Yes.
but depending on the actual technology
Yes.
used, it might be considered one. Yeah, so I understand it still has this grey area question of is it truly ADS that ultimately would be a debate, as Maneesha mentioned at the beginning. But yeah, if you're in the grey area, then there's obviously some risk. Fantastic. And then I guess just maybe the last question to finish, we're going to try and wrap up a little bit early, is do you think, obviously we're talking a lot about risks, obviously we've got our legal hats on here being quite serious and almost ominous. Do you think these rules could slow down the adoption of AI tools in employment contexts? Or do you think the clarification could even help accelerate trust and adoption? Or what impact do you think that will or might have on the industry?
I don't think it's going to slow it down. I think there's a demand for these types of services. I think that they can create amazing efficiencies. I think they can improve diversity. So I don't see them slowing down. I think this could be a deterrent maybe to some smaller players, but yeah, I don't see this area slowing down.
Yeah, I think one notable thing as well is these laws, none of the US state laws, correct me if I'm wrong, are prohibiting. They're not saying you cannot use AI for this. They're just clarifying that do it properly, make sure it's,
Exactly.
it's not discriminatory, otherwings you're fine.
And even the even the EU AI Act doesn't prohibit it. The EU AI Act prohibits certain things like social scoring or things like that, but not use of AI for employment.
Exactly. So yeah, over time, I think that it just sets guardrails that will actually facilitate adoption ultimately. Excellent. I think that's all we have time for. We'll wrap up a few minutes early. So thank you again, Maneesha, Nadeem, Aaron, for a really insightful presentation, really informative, great answers to questions. Thank you everyone for joining and engaging with the topic.